Good morning, everyone. Welcome back. We are here for the proposed ordinance for fireworks and declaration and emergency public hearing number 1. It's May 13th, 2026. It's 9:45 a.m. I will announce this is the first public hearing concerning adopting the Tillamook County fireworks ordinance and declaring an emergency. Sheriff Joshua Brown will be presenting. Would you mind coming down? After Sheriff Brown concludes public input will be next. Good morning, sir.
Good morning. You want me just to go, or is there anything else we got to go through?
Opening the public hearing, Brian's gonna read.
Okay.
Should we do that now or after before the public hearing? I mean, I'm reading it. Okay, gotcha. Go.
I glanced over that, but
I already told him to catch me.
Feel free to help him. He's
Yeah,
sick. So yes,
yeah.
Paul, we get staff presentation first and then we'll have a
There
public.
you go.
good morning, commissioners, Rachel, Brian, members of the public. So this has been a long process. I've been working on it since last year. And really, well, and I'll get into the need, but just to give a little bit of history, fireworks ordinance are not something that's new to counties across the state. And I haven't talked to every county, but I do know that county fireworks ordinance exists in multiple counties. Depending, they vary at levels. Some are complete bans, some are very similar to this, some have their own little twist on it, but it's not new. In fact, Tillamook County does have an ordinance in the county parks ordinance where fireworks are addressed already. So it's already there. This ordinance is very specific to unincorporated areas of Tillamook County. It gives us an additional tool. It's broader than the county parks one, obviously, because it covers more area. And essentially it fills a need, at least as law enforcement, or as I see it. There was a time that we were able to, well, actually I'll come back and I'll get to that once I get into this. So essentially, when we went to draft this, we did look at a couple other counties to see what they had. Some of them were 4 or 5 pages long, and it was decided fairly early that this did not need to be that complicated. Our only goal was to mirror Oregon state law. Oregon state law has already existed for decades, specifying legal and illegal fireworks, all the details that go with it, sales, all that type of stuff. So these laws have been in place, like I said, for decades. We've had the ability to enforce them. This ordinance does not change our ability to enforce state law. It's an additional tool that we have, so we can actually still enforce both. We're never going to enforce both the ordinance and state law at the same time. That's not allowed. It's generally going to be one or the other. Oregon state law it can be confusing when you read it because it sends you to different sections. It reads this law and then it says go to here, and it references back and forth. So if you don't have a clear understanding of how to read Oregon law, it can be confusing. But like I said, it's what's been established for decades. Permit process for fireworks shows, permit process for the tents that go up in the parking lots to sell consumer fireworks. Mortars, Roman candles, things of that nature, those are illegal as statute defines. Consumer fireworks, fountains, sparklers, things of that nature are legal, which again, state statute defines. Nothing about this ordinance changes any of that. And if you look at the ordinance as we go through it, it specifically references those state statutes that we are mirroring. And it says it is adopted pursuant to Oregon Revised Statutes 480.111. Those are the definitions for a group of statutes, and 480.1 or 0.120, which is the sale, possession, and use of fireworks. Again, these are laws that have been established for some time, and we're doing it pursuant to those laws. So we're essentially taking those laws, putting it into our own ordinance. Realistically, the only difference that this ordinance has compared to state statute is the penalty. Right now, if we catch somebody lighting off a mortar and it happens right in front of us and we address that person, our only option is to charge them with a B misdemeanor, which is what state statute designates it as. We don't have the authority or the ability to reduce that or change what we believe it should be. We have to treat it as a crime. Now, we can take them to jail and arrest them. That doesn't necessarily happen. But even if we just do a cite and release, they're still being charged with a crime. They have to go through circuit court. They have to have an attorney. Law enforcement has to write a full report and send it to the district attorney's office, and it's a much more, it's a larger process to go through for something that, maybe somebody doesn't need to be treated that way for. It can be treated a little bit less. This takes that same instance and treats it as a C violation, which the C violation is one of the lowest violations we have. There's A, B, and C. C is one of the lowest ones. We matched the penalties, meaning the fines. There's a presumptive, which is what's written on the citation. There is a maximum and a minimum, which gives a range for the judge to treat it, to stay within if that person is found guilty. These also go to justice court, which is handled far more informally than circuit court for crimes. So it makes the whole process simpler. Deputies or any law enforcement will still have to write some level of a report. It's generally smaller. It's used for citations as opposed to the formal process of reports and sent to the district attorney's office and court. Like I said, it makes that whole process much simpler. And in the end, the person that may be unlucky enough to receive a citation only has to deal with it in circuit court, or excuse me, in justice court, and it's a violation. It's not a crime. It doesn't go on their criminal history. It's not a traffic crime, so it doesn't go on their traffic history, traffic ticket history. So it's a much less cumbersome process for everybody involved, even, particularly the person that may be cited for it. So there was a time when I was patrolling, and Commissioner Fournier, I believe you remember this from your days as being a deputy. We had an agreement with the DA at the time, and that DA allowed us to cite and treat the fireworks violations instead of treating them as a misdemeanor. He allowed us to cite them into justice court and treat them as violations. That was his right to do so. That was a standing agreement for a long time. We no longer have that agreement. So we no longer carry the ability to write it as a violation under an agreement with the district attorney's office. This here allows us to go back to that, to where we can write it as a violation and send it into justice court under the county ordinance. I've had some conversations with people about whether this is good or bad, et cetera, et cetera. And the reality is, I actually was just having one back here. It's actually very neutral. It's very, vanilla, for a lack of a better term. It's very plain. It just mirrors state statute we're already able to enforce. It changes nothing about the legalities of what is legal, what isn't legal. It is absolutely not a total ban. I know there are people in this community that would love a total ban. I know there are people that would love to be able to have the freedom to do whatever fireworks they would like to do, but this is right down the middle. It just mirrors state statute. It is not a total ban. I just want to make sure that that's clear on the record, that that's not what we're doing here. This would not work within city limits unless cities adopt the same thing or sign on to this. So Tillamook City, Rockaway, all of the incorporated cities, this would not be applicable unless they took steps to be a part of it. South County has no incorporated cities, so South County would be, it would be applicable there. Netart's Oceanside area, the areas in between the incorporated cities in North County would also be included as well. The other thing that I want to make sure that I mention is that this does not change the way our deputies patrol, or any law enforcement. We are still going to prioritize calls. We are still going to handle the more serious ones first, just as we have while we've been having the ability to enforce this as a state law. If you've ever been in Pacific City, Rockaway Beach, Sand Lake, Tierra Del Mar on the 4th of July or the day before, especially on a weekend like what we have coming up this year, it is absolute mayhem. There's hardly any time between the fireworks going off. They're going off, over the entirety of the beach, just constant. If you go to Rockaway, you'll have a little break in them when Rockaway does their fireworks show, but as soon as it's over, they're back on, and they'll go for hours. Creates a mess and all of that. We don't have the resources to go down on the beach and try to enforce all that. That's not to say that we don't necessarily make the attempt. But again, while we're trying to get traffic out of the city of Rockaway, or we're dealing with traffic or people fighting or intoxicated persons causing, discontent, those are our priority calls. We're not going to be going out harassing people, that have fireworks and stuff, because we have other priorities. But that's not to say that we don't enforce fireworks laws. We have an obligation, and I can tell you personally, I like fireworks. I think they're really cool. I mean, I like to see them go off. I like this, everything about it. But in the same breath, I have a job to do. Our deputies have a job to do. Our office has a job to do. I've given the example a couple different times that when I was doing Sand Lake Patrol, I was during the day before Sand Lake was busy. I was driving some U.S. Forest Service land up in the forest, and I found one of those Chinese lanterns 3/4 of the way burnt, lying on the side of the road. How that did not spark a forest fire, I don't know. But this was clear up. This was, 10 miles from the beach, and this lantern was laying on the side of a Forest Service road. So we have had numerous beach fires. We've had injuries. So as I said, that I have an obligation to this county to do some level of enforcement within our ability and our staffing for fireworks. This makes it easier. This makes it cleaner, far more reasonable, in my opinion, of a penalty than what state statute defines. We are allowed to create an ordinance that has an equal or lesser penalty. We're not allowed to create ordinances that have more. So for example, I couldn't take an ordinance and say fireworks are really, really bad. We're going to create a penalty that says it's, instead of a B misdemeanor, it's a C felony. We cannot do that. We cannot increase. It has to be, I think there's a term for it. I forget exactly what it is, but we can't do that. So this is right in line with what we are able to do. And that, like I said, is kind of reducing that penalty. So all in all, this is going to make our process much easier, much quicker. It's going to make anybody that may be caught with fireworks a much less cumbersome or difficult process to get it dealt with, because it's just being handled in justice court. I'll just give a quick example, just in case, just so that everybody understands kind of what I mean when I said earlier that we can still enforce both the state law and the ordinance. If we're, patrolling and, right there in downtown Pacific City, somebody lights off a firework right in front of a car in the middle of the road, and we happen to pull right on it, we have a responsibility to take action on that, because they're in the middle of a street and they could have caused injury with their car being right there. So we take action. We would most likely, almost certainly, handle that as an ordinance violation, and we would seize their fireworks, and we'd write them a citation into justice court. They can handle it as a C violation, and it's much easier for them. The flip side to that is, if we're patrolling the Pacific City and somebody's got a van full of fireworks and their door's wide open and they're selling them, mortars and Roman candles and firecrackers and stuff, which are clearly illegal in the state of Oregon, and they're selling them without a permit, we would probably handle that as a violation of state statute, and we would treat it as a crime, because that is a much higher level of seriousness. So that is the officer discretion, which we have in a lot of scenarios, to be able to judge the situation and respond accordingly. So that's the best example I can give. The last thing I'll address before I move on is the emergency clause. If we don't have that's not to say that it is that we are saying or declaring that there is an emergency. This allows us to get this implemented should the board decide to pass this, and it allows us to get it implemented right away, rather than waiting the defined 90 days that is required for implementation. And that is beneficial because July is just around the corner. And what I can tell you is I did just a little bit of quick research, and we've, on the fireworks calls, that we have our own title in our tracking system specific to fireworks calls. And I went back to 2018, where we handled, somewhere in the 40 to 43 range. We started to increase in 2020 and 21, actually getting over 100 calls in those years. 22 and 23 saw a dip back down into the 60s. I'm guessing that it was on the tail end of COVID. And we jumped back up to just under 124 and just over 125. So those numbers are steadily increasing, aside from the COVID dip. But what was interesting about that is that when you look at the month of July rather than the year in total, the percentage of fireworks calls that come in July, every single year is over 50% of the calls for the entirety of the year come within the month of July. And actually in 23, 80% of the calls was in July, and 24 was 68%, and then 25 is 73%. So those first handful of years were in the 50% range, 50 to 60% range. The last 3 years, the amount of calls in the month of July have increased dramatically, which is why we need to be able to have this implemented so that we can enforce it when it's necessary. If we have to enforce it now and this does not get implemented, our enforcement option is state statute and citing people with a crime or taking them to jail. And if we have the ability to write this as a violation under an ordinance instead of treating it as a crime, I see that as a good thing. So that's my presentation.
Thank you, Sheriff. I appreciate that.
Yep.
Prior to public testimony, I'm going to ask county counsel to go ahead and read the rules regarding public comment.
Thank you, Mr. Chair. If you're present or online, would like to comment, make sure that you have signed up to do so. When you speak, please begin by stating your name, where in the county you reside, and who you represent if you're not speaking on your own behalf. Please limit your comments to 2 minutes to keep them related to the matter currently before the board. And please also direct your comments only to the board, not to any other county personnel or those in attendance. And lastly, it would be helpful if you could state whether you're for, neutral, or against the matter on which you speak. Thank you.
Thank you, Brian. Deborah, Debbie, do we have anybody online or is it just in person? Okay, thank you. Okay, first up in the public testimony is Bob Larson from Tillamook.
I'm not here about that.
Okay,
Fireworks, I'm good with that.
okay, so you have no public comment? Okay. Next up will be April Bailey.
I can sit down. Good morning, April Bailey from Nescoin, Oregon. I'm here to represent the people of Tillamook County. As you know, this is a working hour for them. And thankfully, I appreciate you scheduling the second hearing in the evening. So for the public, I'm here to speak for the public record to express concerns about this ordinance. The concerns as follows. It is a perceived added burden to the people, and there is an emergency clause. So let me explain. For the most part, it is the timing of the announcement of this ordinance that has caused objection. The general sentiment in the county and state is that law-abiding citizens are overburdened with ordinances, regulations, laws, fines, fees, and taxes. Adding an emergency clause to any ordinance is also a reason for public concern. There is a current perception at the county level that the commissioners have reduced the voice and influence of the people. This is in regard to such actions as reducing the elected treasurer position to ineffectiveness,
Well, can you,
voting for your own raises.
you're supposed to stay focused on the topic.
Okay, I think this is relevant. You are the commissioners voting on the ordinance, right? So I'm giving you a perception of people and why there's been some objections. But I'll continue and try to finish in the time period. Meanwhile, the residents of Tillamook County have documented less prosecution of property and violent crimes by the DA. It is unfortunate that at this time, the sheriff and commissioners must consider an ordinance to protect the citizens from over-prosecution of infractions that do not cause actual harm to the public, but those crimes that are causing harm are not being prosecuted. In closing, and I'm trying to make sure I'm clear about this, in the future, the people would prefer an ordinance that does not contain an emergency clause and does not potentially lay an extra layer of burden from the county on them. And I would just like to say, I'm not necessarily opposing this. It's the process that I don't appreciate. I do appreciate that they've been working on this for a long time. It's nice to hear that. It'd been nice to have this way before July 4th and not have to have the emergency clause. And as I have also communicated to the Commissioner Fournier and the sheriff, I know that you're following the process, but a little bit more communication to the public prior to a hearing could be helpful in the future to have public buy-in. Thank you.
Thank you. Okay, that is the only folks that we had signed up for public testimony. I appreciate April for you coming in person and doing that. I am at this point going to close the public testimony part of this. And I will now announce that the next hearing, as stated, is the next public hearing for this proposed ordinance is May 28th, 2026 at 6 p.m. at the Tillamook County Main Library. And with that, I will close this public hearing and move back to our regular board meeting. Is that correct? At 10:06 a.m. And we'll move on to agenda item 13, board concerns. Any board concerns, Commissioner Scar?
No concerns from me, thank you.
I'd just like to remind folks that next Tuesday is the election. Tuesday, the 19th is the election. And we recommend that people, if you haven't voted yet, that you consider dropping your ballots off in the approved election ballot boxes or bring them here to the county courthouse, to the clerk's office, rather than use U.S. Postal Service, just to make absolutely sure that your ballots are here on time to be counted.
Agree. I agree with that. Okay, and with that, I will move on to our other meetings and announcements. Budget meeting of the Tillamook County Budget Committee will be held Wednesday, May 13th, 2026 at 1 p.m. That's today. The budget meeting will be held in the Board of Commissioners meeting room here, 106 in the Tillamook County Courthouse, 201 Laurel Avenue, Tillamook. The teleconference number is 1-971-254-3149. Conference ID 866-914-607 #. There is no board briefing scheduled for today due to the budget hearing, Wednesday, May 13th, 2026, or Wednesday, May 20th, 2026. The commissioners will participate in the Tillamook Estuaries Partnership Southern Flow Corridor Tour on Thursday, May 14th, 2026 at 1 p.m. The commissioners will attend an executive session on Monday, May 18th, 2026 at 10 a.m. pursuant to ORS 192.662 parenthetical 2, parenthetical I, to conduct a performance evaluation. The executive session will be held in the Board of Commissioners meeting room, 106 at Tillamook County Courthouse, 201 Laurel Avenue, Tillamook. This executive session is not open to the public. The Local Public Safety Coordinating Council teleconference will be held Monday, May 18th, 2026 at 12 p.m. The meeting will be held here in the Board of Commissioners meeting room, 106 in the Tillamook County Courthouse, 201 Laurel Avenue, Tillamook. Teleconference number again is 1-971-254-3149. Conference ID 155-858-952 #. This is a lot. Memorial Day is an observed holiday for the county and Oregon State Circuit Courts. All county offices in Tillamook County Courthouse and the Tillamook County Library, administrative offices at the jail and Justice Facility, Public Works Department, Department of Community Development, Surveyor's Office, Health and Human Services Department, and clinics, and State Circuit Court will be closed on Monday, May 25th, 2026. And I'll repeat the public hearing. The Board of County Commissioners will hold a second public hearing to consider and adopt the Tillamook County Fireworks Ordinance and declare an emergency. The second public hearing will be held on Thursday, May 28th, 2026 at 6 p.m. at the Tillamook County Main Library, 1716 3rd Street, Tillamook, Oregon, 97141. Teleconference for that is 971-254-3149 with an ID of 866-914-67 #. Copies of the proposed ordinance are available on the Tillamook County website at tillamookcounty.gov /ordinances. Paper copies are available in the Tillamook County Board of Commissioners office. Interested persons can obtain more information by contacting the Tillamook County Commissioner's office at 503-842-3401. Those intending to provide public comment shall appear in person or virtually and testify or email submissions to publiccomments@tillamookcounty.gov. To provide public comments virtually, please register by sending an email to publiccomments@tillamookcounty.gov by 12 p.m. on the Tuesday prior to the hearing. All interested persons are welcome to submit written testimony to the Tillamook County Board of Commissioners, 201 Laurel Avenue, Tillamook, Oregon, 97141. We will now recess. We are going into executive session, so we now recess this meeting But Brian, before we do that, can you tell us what we're going to executive session for?
Yes, Mr. Chair, this executive session is being held pursuant to ORS 192.660, subparagraph 2H, to consult with legal counsel concerning the legal rights and duties of a public body with regard to current litigation or litigation likely to be filed.
Great. Thank you. With that, I will recess this meeting at 10:10 a.m.